Before we begin, let me introduce some members of town government that act as advisors to this board. To my left is Valerie Mansell, counsel to the board. To her left is Kelly Brown, representing the planning department. To her left is John Bongino, town building director. Now let me tell you why you're here tonight. New York State statute requires that any town that adopts zoning must also have a board of appeals to act as a relief valve, so that those persons agreed by strict application of the zoning ordinance can seek relief without the expense of going to court. Town board can give Board of Appeals additional powers such as special exception approvals, site plan approvals. In Smithtown, the town board has given this board authority regarding certificate of existing use and some special exception uses. The most common kind of application before the board are area variances. Area variances deal with dimensions such as lot area, frontage, height, setbacks, and parking spaces. New York State statute mandates that the board must consider the following 5 criteria in area variances. When you come to the podium to present your application, you need to address these variances. They're posted here for you. Number 1, whether an undesirable change will be produced in the character of the neighborhood or detriment to nearby properties will be created. Number 2, whether the applicant has other feasible alternatives. Number 3, whether the variance is substantial. Number 4, whether an adverse impact on the environment will be created. Number 5, whether the alleged difficulty is self-created. The statute requires the board to balance the interests of the applicant and those of the neighborhood or community. This statute further requires that the board shall grant the minimum variances shall deem necessary and adequate, and at the same time preserve and protect the character of the neighborhood and the health, safety, and welfare of the community. The board has the power to impose reasonable conditions for granting variances. Use variance is so rare we won't describe the criteria unless there's an actual application before us. Special exception applications are different than area variances. When we have a special exception application before us, I will explain the different criteria for each. Regarding procedure, cases will be called in order that they are advertised. When your case is called, please come forward, submit your affidavits and mailing receipts to Ms. Brown, and then you will be sworn in at the podium and be given the opportunity to explain to this board why you need the variance. After the applicant is done speaking, all interested parties will be given one opportunity and only one opportunity. So please, organize your thoughts, keep your remarks factual that are related to the case. Then I will ask the applicant to come back to the podium to answer your concerns. The board will then close the case and reserve decision. After all the hearings are closed, the board will review the cases and decide some of them. Others will be reviewed at a later date. There are 3 ways to find out the results of the case. Number 1, you can wait until after the public hearing, but there's no guarantee the board will act on your case tonight. Number 2, you can call the planning department tomorrow afternoon. And number 3, applicants can wait and be notified by mail. We do have some adjournments, so let me tell you what the adjournments are. Case 16470, Cosmetic of Smithtown. It's located on Route 347 and Terry Road. That has been adjourned to July 26th. Is there anyone here for that case? Okay. So that will be heard on July 26th, all right? The next case that is adjourned, it's a rehearing, case 1-16425. It's Christine DeMatti. It is on Gibbsby Drive in Smithtown. That has been adjourned to August 9th. Was anybody interested in that case? Okay. First case for tonight then. Case 16460, Mark and Jennifer Riley, 100 Genovese Drive, Comac. Location, southwest corner of Genovese Drive and Schuyler Drive, Comac. Property zone R10. Request variance to reduce the required front yard on Schuyler Drive from 40 feet to 28 for proposed 6-foot fence. May I have your name, please?
Mark Riley.
And your address, Mark.
100 Genesee Drive in Comac.
Okay. Will you raise your right hand, please? Do you swear to tell the whole truth and nothing but the truth?
I do.
Thank you. You want to tell us why you're here, please?
I'm proposing to construct a 6-foot-high fence 12 feet into the front yard.
Okay.
Oh, it would leave a 28-foot setback from the property line.
Mm-hmm.
And that's pretty much it. What we're trying to do is enclose a side door that we have that faces Schuyler Drive. We want to enclose that into our yard so that the door isn't accessible from Schuyler Drive anymore.
Planning? Anything? Okay. Gentlemen?
No,
Okay. Thank you so much.
thank you.
Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved.
It's regularly moved in second. All in favor? Aye. Opposed? Motion carried. The next case is case 16461, Greg and Carrie Reinhold, 14 Durian Lane, Comac. Location. Ladies and gentlemen, this is a special exception. A special exception is a permitted use if they meet all the criteria. If they do not meet all the criteria, then they have to ask for variances. All right? A special exception permits temporary living quarters for parents. Variance to relax the special exception standards that limits the temporary living quarters to 600 square feet. Proposed 1,295 square feet addition. Variance to waive the special exception standard that requires compliance with the floor area ratio requirement. Variance to increase the FAR from 25% to 36%. And your name, please?
My name is Carrie Reinhold,
And your address, Carrie.
14 Dorian Lane, Comac.
Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I do. We are,
Use the mic as much as you
I'm
can,
sorry.
okay? All right?
we are proposing to make a mother-daughter out of our home. We are only going over the existing footprint of the home.
Okay. You want to tell us a little bit more?
My parents sold their house. They currently have no place to live. They're living in with us, my husband and my son. My father is disabled. He has heart issues. He's had a triple bypass. So they could no longer afford to maintain the home they were living in. They've come to live with us. This is why we're trying to do the extension upstairs for them. And the only, as I said, it's within the exact footprint of the home. The only extension is for the external staircase.
Okay. I'm just going to tell you that there's a PAR on this. Was she able to read the PAR?
Not that I am aware of.
Okay. Usually we give that to them before. Okay. Do you want to go over the PAR or would you like me to?
Would you please,
Yeah.
Madam Chairman?
All right, let me explain something to you. That when you have this mother-daughter, you have to be able to turn it back into a single-family home. When looking at the application and looking at the plans, the planning department feels that it does not meet the standards for mother-daughter. All right, because you have, in other words, you're making it. You have 3 bedrooms on the first floor. 3
Yes.
bedrooms on the second floor, a kitchen on the first, the kitchen on the second. It has the potential to be a 2-family home.
The reason that there are additional bedrooms, I know it's a 3-bedroom, is my adult sister does currently live with my parents, and my parents are raising my nephew.
Well, let me just tell you, it will not pass for the special exception. So this is what I'm going to ask you to do. We're not going to make a decision on it. I'm going to ask you, we're going to adjourn this. You need to go back to the planning department and work with them, and you're going to have to reduce it in some way and show that it could be a single-family home. Because it's very substantial. You're going from 600 square feet, doubling it, to 1,200.
May I ask a question?
You may.
Within our own neighborhood, I've walked around, there are dormers that do cover the entire footprint. We're not going any larger than anyone
Yes,
else.
But that's a different situation. That's not a special exception for mother-daughter.
Okay, and
Okay.
just one more question, please?
Sure.
The home that my parents just sold was a mother-daughter. It was more than 600 square feet.
That's our guidelines, so I'm going to adjourn it,
Okay.
all right? So give you the opportunity to go back to refigure it and replan and work with the planning department.
Okay.
All right? I'm going to give you some time, so I will adjourn it until August 9th. All right? Gentlemen, are there any other questions? Okay. Was there anyone here that was interested in this case? Okay. All right, they will be back on August 9th. Okay. Next case is case 16462, FMF Properties, James Fox, 152 Highland Drive, Kings Park. Location, west side of Gary McMahon, I think it's Court, north of Berg Avenue. Am I correct there? I think we have it as Kings Park. Property zone R10. Request variance to increase the maximum paving in the front yard from 25% to 34%. Increase the maximum permitted driveway slope from 8% to 11%.
Donald King, 75 East Main Street, Kings Park, New York. I agreed to present this for Jimmy Fox tonight because he told me buy me 24 sandworms, which is probably the biggest fee I ever got from him. And I agreed to go forward. What happened here, planning set these lots up. And as a result, the configuration of the lot causes this problem with respect to the slope and with respect to the additional square footage that he needs for the driveway. That's the problem.
Okay. Let me just tell you, Mr. King, that I was there on Monday, yesterday. It does not look like that the slope is 11% for that driveway.
You want Jim to come up and discuss that, please?
Less.
Maybe the ad.
Well,
I was instructed,
let me just swear you in. Let me have your name
James Fox,
and your address.
152 Highland Drive, Kings Park, New York.
Okay, raise your right hand. Do you swear to tell the whole truth and nothing but the truth?
I do.
All right, use the mic as much as you can.
I've altered the driveway as much as I can, but under the permitted, I have a permit to construct the house, and I was concerned that in order to get a CO, I would possibly have to get the variance for that driveway. And also, the size of the driveway would be over the 38%, but in some altering of the grade, I would like to make it less, but I cannot determine that until it's finished. But my concern is when I get time to complete the house, that I wouldn't be able to schedule a variance, the timeline for the homeowners to move in. That will be all on my final survey, the exact slope and percentage when I submit it to both engineering and the building department, but I cannot take the time to then come back to this board for that. So I'm kind of preparing myself for inevitably what may or may not happen there.
Okay, so you're definitely not going over 11%, but you may be much lower than that.
I could be less, yes.
Yeah, okay.
And then the driveway is just in front of the two-car garage,
I
but
see
because
that.
of the narrow lots, like Mr. King explained, that's what I have there.
Okay. Planning, any comments?
No problem.
Gentlemen?
No question.
Okay,
Thank you.
thank you. Was there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved.
Really moved to second. All in favor? Aye. Motion carried. Next case is case 16463, Standard Microsystems Corp., 80 Arcade Drive, Hyde Park. Location, north side of Arcade Drive, east of Adams Avenue, Hyde Park. Property zone LI. Request variance, reduce the minimum required parking setback to front property line from 50 feet to 36 on Suffolk Court. Reduce the minimum front yard's landscape area from 80% to 72%. Reduce the number of planting aisles from 56 to 0.
Madam Chairman, members of the board, my name is Vincent Tremarco. I represent the applicant. I've submitted the affidavit of posting and mailing to Kelly Brown. You might recall we were here maybe 4 or 5 years ago, and we requested parking space variance. This board granted us the variance, and we're back here today, believe it or not, to add parking spaces to the standard microsystems facility. The old variance granted us 532 spaces. We built, because of land bank parking, 451. We'd like to now add physically 142 more parking spaces. Now, one of the things that doesn't make sense, and I think Mike Marinas, our engineer, could touch upon that, is planting islands from 56 to 0. Yeah. It's not correct, and there are planting islands, and Mike, if you wouldn't mind, perhaps you could show them.
Well, let me swear him in so he can talk.
Sure.
Speak. May I have your name, please?
Michael Marinas. I'm with
So your last name, please?
Marinis. I'm a professional engineer with the firm of Barrett, Bonacci, and Van Weel,
All right.
175A Commerce Drive, Hop Hog.
Okay. Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I do.
Take the mic with you, if you don't mind.
Thank you. All the parking reconfiguring that we're proposing is in the rear of the site, which is the northern portion of the site. Previously, the site plan approval, as mentioned, we had 451 stalls, which were oriented in the opposite, in a east-west direction. By configuring them to the north-south, as we have shown, we were able to increase the number of stalls. The variances that we are requesting are for the width of this landscaped area fronting Suffolk Court, because it's considered a front yard. We have a through lot situation, so Suffolk Court is considered a front yard. So we're reducing that buffer width from the required 50 to 36 feet. I had met with the planning department several times to go over this configuration, and this was what you see here as a result of several meetings with the planning department. The other item is with regard to the number of planting islands, and I had reached out to the planning department today, but I hadn't gotten a response. The requirement in the town is to have one landscaped parking island for every 20 stalls.
Right.
And each of these rows is in excess of 20 stalls, and that's the reason for that variance. By my count, I get 15 landscaped islands. So I don't know if there's a typo there or where that came from, but we do acknowledge the fact that each one of these islands, each one of these rows should have a parking island.
That's the way we counted it. We counted 20, we counted 1.
I did it the same way. I couldn't get the number, but I did reach out to staff today, but
Yeah.
I didn't get a response in time.
Okay, let me just ask you some questions, because I was there yesterday. The parking, the islands that are there, are they staying the way they are now?
Everything north of the back of the building is going to be completely reconfigured. Presently, parking runs in this direction. So
Right.
So that's all going to be reconfigured. We're restriping it, and we're putting in all these islands here are proposed islands.
Okay, so they are proposed. There is a berm there, is that
Yes,
staying,
in the
or is that
back.
coming down?
Yes, it will have to be cut into slightly, but the intention is to leave this area as buffered as possible.
Okay, so most of that berm will be staying?
That's correct.
All right, because when we were there yesterday, you had a lot of parking spaces, empty, vacant.
Understood. I'll let the attorney discuss
Okay.
the reasoning for the
Okay, thank you.
request.
Currently, Standard Microsystems has 320 employees, So obviously, with 451 parking spaces built, you did see some vacant parking. What Standard Microsystem intends to do is to sell the property and lease back a portion of the office space, and they'll maintain a large presence at that building. So considering situation, they don't really know who's coming in there, but they would rather have the most spaces that they can have under the code with these slight variances rather than have to come back later. So they want to build that, do a whole site plan, build all of those spaces, and be ready for whoever decides to purchase the property. But I want to emphasize that they are staying. They're not leaving, and they're going to lease back for at least 15 years. They want to stay in Hop Park, in the industrial park, but the economic situation is such that this is what the powers that be in Microsystems decided to do for their own betterment, and also that betterment of the employees in the town who will continue to work for Standard Microsystems. I'd also like to emphasize that the setback 50 from 36 on Suffolk Court, as Mike said, there is it's a through lot. There is no building on Suffolk Court that we back up to, so really the 36-foot setback really doesn't have any effect on any other building. There, of course, are buildings across the street. We don't think that this would have an adverse effect on the character of the area or nearby properties. Whether the benefit sought could be achieved by some other method, I guess we didn't have to come here, and we could have sold the building and leased back the building, but we wanted to do it the best way possible, and that is to get as many parking spaces as we can without encroaching on our neighbors, so that whoever comes in there will have adequate parking. The reduction of landscaping from 80 to 72% is also de minimis. Whether the requested area variance is substantial, well, it's really not substantial, and the funny part of it is we want to put in more spaces. We don't have to. You gave us a variance for 532. You allowed us to build 451. Now we want to add 142 more spaces. Most of the time I'm here asking this board to give us a variance on parking, not to allow us to put in more parking. And by you allowing us to do that, by granting us these few other variances that we're asking for, will certainly make a better facility. So we ask the board for its favorable consideration. The last thing was the difficulty self-created. We didn't do it yet. Obviously, we need your permission to do it. And also, it wouldn't have any environmental effect on the surrounding properties or the property itself. All new storm drainage is going to be part of this application, and of course, the engineering department would have to approve all of that. So we ask the board for its favorable consideration. If you have any questions, I have people here from Standard Microsystems, and of course, Mike Marinas.
Does planning, do you have any questions, planning? From
No
planning?
questions.
Okay. Gentlemen?
No question.
No question.
Okay. Thank you
Thank you.
so much. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved.
Second.
Ready, moved and second. All in favor?
Aye.
Aye. Motion carried. Okay. Next case is case 16464. Matthew and Michelle Weiler, what is it? was Thaler, okay. No, 64 Gilbert Avenue, Smithtown, locations outside of Gilbert Avenue, west of Ridgely Road, Smithtown property zone R15. Request variance to reduce the minimum front yard setback from 45 feet to 34 feet for an existing 58 square foot porch and 186 square foot first floor addition. Permit environmentally sensitive land, depth to groundwater less than 10 feet to be altered for a 112 square foot and a 186 square foot first floor additions, 58 square foot porch, 334 square foot covered deck, and a 153 square foot pagoda. And
34, not 64.
34, Gilbert?
what do you say?
You said 64 Gilbert is the address? It's 34 Gilbert.
I'm sorry, it is 34, I have it right.
Oh, okay.
Yeah. Okay. May I have your name, please?
Sure, Matthew Woytheller,
And your address, Matthew?
34 Gilbert Avenue, Smithtown.
Okay. Are you going to speak?
I'm Michelle Woythaler, 34 Gilbert Avenue,
All right.
Smithtown.
Will you both raise your right hand, please? Do you swear to tell the whole truth and nothing but the truth?
Yes.
Thank you. You want to tell us why you're here, please?
Yeah, my wife and I, we bought the property in December, and we actually, the previous owners, the Giordano's, are here to answer any questions because we felt that, you know, since we just moved into the house in December, they would probably be better equipped to answer questions about what was done because, you know, we didn't make those changes. So they are here if you want to speak to them or ask them any questions.
Okay. Well, I'm assuming they did it without COs. They
Correct.
sold it without COs. Okay.
Right.
Did you get a letter, a note from the environmental department?
Yes.
Saying that you need to do a test hole?
It was actually done this morning.
It was done this morning?
Yep, and it was funny because I received the letter today in the mail, and the gentleman came this morning.
Okay. And do you know what the results of the test hole was?
I do not. He came this morning at like 8:30 in the morning, so.
Okay. Just let me tell you, that means that we won't make a decision tonight.
Okay,
All right? We have to wait for the test hole, and we have to wait for the environmental department to issue a secret report.
okay.
All right? Is there anything else you'd like to add?
No,
Okay. Planning?
Nope, no comment.
Gentlemen, anything? Okay, thank you so much.
okay, so we'll have to come back, I guess, or?
No, you
or
don't have to
Oh,
come
okay.
back.
Just,
When we get that report and everything, we will make a decision, and you can call the planning department. It's going to take at least, well, first of all, it won't be for at least another 2 weeks.
Okay.
Let's hope I have that
Okay.
report by our next meeting.
okay.
All right?
All right, thank you very much.
You're very welcome. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
Readily moved and second. All in favor?
Aye. Aye.
Aye. Motion carried. Next case is case 16465, Douglas and Michelle Gerotman, 5 Silo Road, Comac. Location, east side of Silo Road, north of Harvest Lane, Comac Property Zone R10. Request variance to increase the maximum floor area ratio from 25% to 27%. Reduce the minimum side yard from 12 feet to 11, 2 feet existing. Reduce the total side yard from 28 feet to 18 feet existing for a proposed 255 square foot first floor addition. And the applicant, please?
Doug Dropman, 5 Sadler Road, Comac, New York.
Okay, raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I do.
Would you like this gentleman to speak for you?
Yes, I would.
Thank you. May I have your name, please?
Ken Shulman, architect, 209 Lynn Avenue, East Northport.
All right, Ray, will you please, first of all, spell your last name?
Schulman.
Okay, raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
Yes.
Okay.
We are proposing a first-floor addition for an expanded recreation room. We will be proposing a side yard setback of 11 feet where 12 feet is required. This addition will be built under an existing second-floor addition which has a 9-foot setback. This was granted a variance back in 1999 under case 12626. So we'll be stepping in the sidewall to have less of a variance than was previously granted. Also, we will not have any windows on that side of the property like the second floor addition has to maintain some privacy between the adjacent house. The reason the property line is on an angle and angles in towards the rear of the property, that's what created this difficulty. I've taken the floor plan and actually overlaid the property line to show how little of the addition actually requires a variance. It's about 5 square feet. If you like, I could submit that. Also, we're seeking a variance for lot coverage. We are only 1.8% over on the lot coverage, which is fairly inconsequential. Also, we're seeking a 6-inch variance for aggregate side yard, again, which is very, very small.
Okay. Planning, is there any comments?
No comments.
Gentlemen?
No. Oh,
Okay. Thank you so much. Thank you. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
so moved. Second.
You ready to move the second? All in favor?
Aye.
Aye. Motion carried. Next case is case 16466, Best Friends Veterinarian Care, location, north side of Smithtown Boulevard, west of Southern Boulevard, Nesconset Property Zone, NB. Request special exception to permit a 3,080 square foot animal hospital. This is a special exception. Mr. King, did you get the PAR for? Yes, I did. Okay.
Donald King, 75 East Main Street, Kings Park, New York, attorney for the applicant. This is an existing shopping center. My clients intend to occupy 3,080 square feet. They do not need a parking variance. The shopping center with its current uses meets the parking requirement for the town of Smithtown. We don't need any variances of any kind. As far as the health department goes, we have more than adequate flow. We're just waiting for a letter back or permit back from them to DEW. Clients intend to occupy this building, and we meet the general standards and we meet the specific standards. If you want to go over those, I'll be happy to answer them.
It's up to you. Kelly, would you like to go around, go over the standards with?
The only thing that the planning...
You need to do the mic, honey.
The only thing that the planning department was concerned with was that the veterinary hospital could get rid of the animal waste.
Yeah, I can address that if you'd like. I'd like to hand up, if I may, a couple of sheets that show you the interior of the premises, and by number you'll be able to identify which room is which room. Dave called me yesterday. Dave Flynn indicated that the planning department was in favor of this, and they had no conditions to impose upon us with respect to, if you guys see fit to approve it. With respect to the waste, spoke to my clients about that this evening. It'll be bagged and placed in dumpsters, and there'll be no odor from it. Medical waste will be picked up by a private company maintained within the building. They also raised a question about subsection D. We meet the noise ordinance requirement of the town of Smithtown as it applies to the location, and there will be no odors. These ladies have been at this for 13 and 14 years respectively. They want it clean, it will be nice, and the neighbors will not be impacted. The nearest house from the edge of the building is 90 feet from the edge of the building to the house, and the other house that's to the rear is 160 feet away, and they will not be impacted whatsoever.
Okay. Is there anything else?
No further comment.
Gentlemen, any questions? Okay. You know that we did get Suffolk County Planning, that was local determination, however, we do not have a secret.
Yes.
Okay. And I do have the letter from your architect?
Yes.
Okay. Was that put into the file?
I called, we sent it over to Sue. I have another letter here.
I have one myself, so I'm just
Another.
wondering. Let me just make sure, please.
She said she was going to insert it in the file.
Okay, I'm pretty sure she did. I only need one copy, Mr.
Sent with the
King.
building also.
Huh? Okay, great. Okay,
Thank you.
okay, thank you. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
Billy, moved in second. All in favor?
Aye.
Aye. Motion carried. Okay. Next case is case 16467. Sir Ari Padamanam. You probably wouldn't get Jen and Deo either. Okay. 639 Meadow Road, location. That's in Smithtown. Location east side of Meadow Road, south of Edgar Drive, Smithtown, property zone R21. Request variance to reduce the minimum side setback from 8 feet to 7 for an existing pool. Reduce the minimum side yard setback from 8 feet to 4 for a proposed 288 square foot deck. Reduce the setback for 596 square foot deck on grade from 3 feet to 2. Increase the maximum paving in the front yard from 25% to 47% existing. Permit environmentally sensitive land slopes in excess of 15% to be altered. Pool, deck, and steps. Reduce the setback from any slope greater than 15% from 10 feet to 0 for the pool, deck, and steps. Okay. And your name, please.
I'm Arun Padmanabhan. I reside at 639 Meadow Road.
Okay.
I'm not nominating James Zapka to represent me.
All right, let me have, first of all, raise your right hand. You swear to tell the whole truth and nothing but the truth.
I swear to tell the truth and nothing but the truth.
Thank you.
Thank you.
And May, come up, please.
James Apka, representing Todd O'Connell Architects.
First of all, spell your last name.
Zapka.
Okay, and give me your address.
1200 Veterans Highway, Hop Hog.
All right, now raise your right hand. Do you swear to tell the whole truth and nothing but the truth?
Yes.
Okay, thank you. All right, you want to tell us why you're here, please?
This particular property has many challenges and creates significant hardships which need to be addressed. The property is situated on a 51-foot wide lot, has less areas prescribed in an R21 zoning district, and has slopes greater than 15%, and is located on Meadow Road, which yields high traffic and speeding areas. I will start with the paving the front yard. Although the request may seem excessive, the property grade and due to the front yard existing paving under the code will only allow a 12-foot wide 12-foot wide 2-car deep driveway. This would create a dangerous situation as it is important to have a 2-car wide driveway to manipulate the vehicle during high traffic times. We would also like to add that the owner represents that the driveway has existed as is for as long as he has owned the house. As far as the pool being only 7 foot from the property line where 8 foot is required, and the deck being 4 foot from the property line where 8 foot is required, we feel that this is a reasonable request as the property is only 51 foot wide, and in conjunction with the topography, utilizing some of the side yard is a practical request for relief. The deck that exists is on grade and is basically has no effect on the environment as it lends itself to landscaping. Once again, use of the yard, which is difficult in this 51-foot wide, heavily sloped, undersized property, which yields only a 9-inch relief request. Finally, we realize that the request to manipulate the slope may be from 10 feet to 0, but the fact that we are manipulating the slope slightly just to resist damage to the pool from runoff and give a slight amount more of usable property for the family to enjoy their home and property. Based on all the previous comments, we do not feel that this has a negative impact on the surrounding neighborhood as the relief sought, with the exception of the pre-existing driveway, cannot even be seen from the streetscape, nor will it have negative environmental impact. Of course, the issue may have been resolved in other ways, but due to the hardships we are faced with, we feel that the requests are reasonable. We realize that some of these requests may be self-created, but we feel the benefit achieved by the owner far outweighs the detriment to the surrounding neighborhood.
I noticed that the 4.9 for the deck is only at one corner of the deck.
Correct.
Okay. Planning? Gentlemen?
No.
Okay, thank you so much.
Thank you.
Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
Reverend moved in second. All in favor?
Aye.
Aye. Motion carried. All right. Next case is case 16468, Gail and Greg Ross. 8 Tower Place, Smithtown. Location, northeast corner of Beverly Road and Tower Place, Smithtown. Property zone R15. Go ahead. Request variance to reduce the minimum front yard from 45 feet to 35 feet for proposed 252 square foot second floor addition. Permit environmentally sensitive land depth to groundwater less than 10 feet to be altered. Increase the maximum gross floor area of a lot from 25% to 100% due to environmentally sensitive land. Thank you. I'm assuming that the groundwater is, what's this? It's hard to see. What do you think it is? Is it 10 feet? No. We're reading it, the test hole report. It's hard to see it.
Okay.
About 5 feet, okay. Yeah. Okay. I don't believe we need these pictures. We do have,
Okay, I just want to give everything you needed.
okay. Okay. All right. Let me have your name and address, please.
Gail Ross, 8 Tower Place, Smithtown, New York.
All right. Raise your right hand, please. Do Do you swear to tell the whole truth and nothing but the truth?
I do. What we're trying to do is put a second-story addition on the proposed second story. We already have a variance for the first floor. For the 252, we have a variance and a permit that was granted on the 22nd of February. Of course, with the weather, took a while to get the foundation in there. We really need it for storage space. We're absolutely at our maximum. I'm going to be having my mom in that space, and since it's only a 252, it's basically just a room. When you start to have things like clothing and 3 teenage daughters, or when they're 20s, our closets are about this big. So we just really, really need storage space, and that's all we're looking to do with that area. With regard to the test hole, not quite sure why it wasn't asked for the first time around, but regardless, it's there. That was about a month ago, and that looks like it's all in order. As far as change in the neighborhood, the first floor, everybody was accepting of that. It actually will look better having a second floor, otherwise it'll look like this and a weird garage. I think the integrity of the neighborhood will look better that way. There's kind of no other way to achieve storage space. And I would say storage, I literally mean closets and storage. I don't mean to store. When you have 3 kids, you need closets. And then my mother's stuff as well. I don't believe it's substantial because we already have the first floor. There is no impact because we've already been granted, as I said, the first part that was already granted to us, so there won't be any negative impact on the
Slow down
neighborhood.
a little bit.
I'm sorry, that's how I
Can you
speak
get it?
all the time.
He needs
Good
to.
thing he's quick, right? My husband can transcribe for him. I'm the only one who can understand me. And whether I don't see that it was allegedly self-created. We weren't sure if we were going to do it in the first place. We went back and forth with it for financial reasons. And then when we put it up, we're getting ready to build, and we said, oh my gosh, we need storage space. So then they said, okay, now you got to come back. So for 2 months, we've been sitting with our foundation waiting there, and we'd like to move forward, and we hope that you will grant that for us so we can go forward with the proposed addition on the top. And that's pretty much it.
Okay. It says 100% due to environmentally sensitive land. John, do you know what the actual FAR is?
No, I didn't figure it out, but the lot itself is over 17,000 square feet.
Oh.
And there are no notes in the file regarding that it reaches its maximum of 25%.
Okay. So it's 70,000 square feet? 17,000 square feet. Okay. Planning?
No comments.
Gentlemen? Okay.
Thank you. Shall I
Thank-
come get my pictures as well?
Yes, you can take these. Thank you so much.
And everything else she has, she keeps, yes?
Thank you very much. Okay. You can leave. You can call tomorrow afternoon if you'd like. You're welcome to stay. It takes us another couple hours, so.
She wants to know.
Uh-huh.
She wants to know if anybody's going to ask any
Oh,
questions.
yeah, I'll see. I'll just see if anyone, just wait one. Okay. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
All right, ready, move to second. All in favor?
Aye. Aye.
Motion carried. Thanks. Next case is case 16469, Rosario and Marie Bracco, 8 Holiday Park Drive, Hop Location, west side of Holiday Park Drive, south of Cardinal Lane, Hop Property Zone R10. Request variance to reduce the minimum rear yard setback from 50 feet to 43 for a proposed 134 square foot sunroom. And your name, please.
Rosario Bracco, 8 Holiday Park Drive, Hauppauge, New York.
Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I do.
Okay. Would you like this lady to speak for you?
Yes, I would.
Thank you so much.
Good evening. Diana Laspisa, 4 Hamilton Court, Quorum, New York, 11727, with Morano Expediting.
Okay. Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I do. Good evening, Madam Chair and members of the board. Diana Laspisa with Morano Expediting, here to speak on behalf of the property owners, Rosario and Marie Bracco. We are here before you tonight requesting permission to construct a 13-foot 3-inch by 10-foot 11-inch sunroom addition off the rear of the existing dwelling. The sunroom will be holding a 43-foot rear yard setback off the property line, whereas 50 feet is required in an R10 zone. To the rear of the subject parcel is industrial property. This will have no effect on any residential land. In addition, as you can see from the photographs submitted, this property is completely screened all along the rear and both side property lines. So the sunroom will not be visible to any neighboring residences. We don't feel the variance as it is before you is considered substantial, as it is only a 14% relaxation or 7-foot encroachment of the zoning code, and it is not going to be used as habitable space. If the board has any questions, I would be more than happy to answer them at this time.
Planning? No comments. Gentlemen? Okay, do you want to look at these pictures also first before you? Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
Readily moved and second. All in favor?
Aye.
Aye. Motion carried. Thank you. Next case is case 16470, Cosmetic of Smithtown, has been adjourned to July 26th. Okay. Next case is case 16471, Fred Grindel, 24 Pond View Drive, St. James, location, east side of Power Ave Drive, south of Kings Highway, Hauppauge. Property zone LI. Request variance to reduce the minimum parking from 70 to 62 spaces. Reduce parking setback to rear property line from 6 feet to 0. And your name, please.
Manfred W. Grinder.
I'm sorry?
Manfred, M-A-N-F-R-E-D.
Okay.
W. Grinder.
And your address, please.
24 Pondview, St. James, New York, 11780.
All right. Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I do.
Would you like this gentleman to speak for you?
Yes.
Okay, thank you. Hello, may I have your name and address, please?
Yes, Tim Jordan.
Speak nice and loud, Jim.
Tim Jordan, 11 Old Cow Path in Miller Place, New York 11764.
Okay. Spell your last name.
Jordan.
All right, raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I do.
Okay. You want to tell us why you're here, please?
Here for variance on 15 Power Drive to maintain on interior alterations from warehouse to office space. The issue has come about that the parking is insufficient. We currently are holding 62 spaces, and the requirement for the amount of office space we have requires 70. Our additional variance is that some of those parking spaces are to the rear of the parcel and are not holding the required 6 foot to the property line. They are holding 0. In regards to that, there is, I wouldn't call it landscaping, it's more like overgrown brush that is creating, I would say, around a 4.5 foot buffer. So this could be changed as far as the setback to the rear for the parking. They're not literally parking the cars on the rear property line. There is a setback that they are holding. When Mr. Grindel first opened up, he was an optician, and he opened up in 1973. He retired and leased the building to Catholic Health Services. For about 8 years, Catholic Health Services was in there, and their business thrived, their needs changed, and he accommodated those needs with some additional office space. They have an interesting operation where they have a lot of medical equipment that requires cleaning, special storage. So upon looking at the floor plans, you can see it's a bit of a maze in there, but it's laid out for their needs and how they've been operating.
Okay. A couple of things. First of all, you know there is no decision tonight because this has to go to the health department?
Yes, I'm aware of that.
Okay, you have to make that application. All right, and the second thing is that you know that some of the board members go to the sites?
Yes.
So I was there yesterday. There is a trailer on that, in that site?
I believe there is a trailer on the
Is it
adjoining
yours?
properties.
It's not your trailer?
The adjoining properties. Mr. Grindel, would you? Yes, there is. He is confirming that.
Yeah, I know.
Okay.
But I don't believe that can stay there.
Okay.
Okay.
That will be addressed.
Okay. A container. Container. All right. John, you're not allowed to have the container, this large container there, are you?
Correct.
Okay. All right?
Absolutely.
Okay.
It'll be addressed.
Okay. All right, and then as soon as we get a secret, we'll make a decision.
I'm sorry?
As soon as we get from the health department and
Right.
everything, we will
You
make a decision.
reserving upon health department approval.
Yeah.
Understood.
All right?
Thank you so much for your time.
Thank you. Planning?
Madam Chairman, I would just like you to know there
Excuse
is...
me. Yes, planning.
There is a letter dated July 6th from the Environmental Protection Agency telling him that he does have to go to the Department of Health, and also they want him to submit a revised application materials which clearly identify the existing proposed uses of the remaining 891 square feet of building space. Did you receive this letter, sir?
Yes, I did, and I also was able to contact the architect's office and get that discrepancy resolved. The walls are over a thick foot. I'm sorry, 1 foot thick, and that is not calculated into that equation, as well as the bathrooms. The office space and the warehouse space is what's been determined, and you know, the bathrooms were not included in that, as well as the actual thick walls themselves.
Thank you.
You're welcome.
Pardon me? Yes. Yep, I did, yeah. And so there's no decision anyway tonight.
They're not going to write a secret till their questions are answered.
Yeah. Okay. Okay. Okay, so do you understand when you have everything submitted, then they will make a determination?
Yes, and the trailer is not meeting code. The storage container on the property is not meeting code.
Right.
That is the
I know.
container?
Even a container is not permitted? No. All right?
Okay.
Thank you.
Thank you again for your time.
Thank you so much. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain the motion to close the hearing.
So moved. Second.
Then move to second. All in favor?
Aye.
Motion carried. All right, case 1-16425, Christina Diamante, has been adjourned to August 9th. All right, and now we will be going to the adjourned hearings. Case 16445, Suri Rajini, 12 Gilbert Avenue, Smithtown location, southeast corner of Gilbert Avenue and Terry Road, Smithtown, property zone PB. Request a special exception to increase the FAR from 2,500 square feet to 2,740 square feet existing for a two-family residence. Variance to reduce the minimum lot area from 15,000 square feet to a 13,752 square feet. All right, this is a special exception. It is a permitted use. This is permitted to have a two-family residence. All right, what they're asking for is to increase the FAR from 2,500 to 2,740, and that's what they're asking for as far as the variance is concerned. All right, may I have your name, please?
Rajendra Suri.
And your address.
Pardon?
Your address.
You what?
Your address. Where you live.
I live at 10 Spring Meadow Drive.
Okay. Okay. Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I'll say the whole truth, nothing but the truth.
Okay, thank you. Would you like this gentleman to speak for you?
Yes.
Yes.
Yeah, he will speak for me.
Okay, thank you. All right, may I have your name, please?
Sure, it's Scott Kahn, 16 Old Field Road, Setauket, New York.
Okay, spell your last name.
K-A-H-N.
Okay. Yes.
Not. Madam Chairman, the planning board has not yet done a PAR on this,
Yes.
so I just wanted to let you know that.
This gentleman might want
Yeah.
to have an opportunity to respond to anything that the planning department might want to say.
Do you realize what we're saying?
Uh,
There's no PAR on this?
Right, the planning department hasn't reviewed it yet.
Right. So, do you want to go through it and what do you call it? If there's a problem when the PAR comes out, I'll let
I
it
guess
come back, or?
That would be fine.
Okay.
Yeah.
Why don't you do that?
That's fine.
Okay.
Good evening, Madam Chairperson and members of the board. I'm here tonight representing Mr. Suri, the owner of 12 Gilbert Avenue in Smithtown. And Mr. Suri seeks a variance for a change of use from a one-family dwelling to a two-family dwelling to remain in a PB zone. As you're aware, a two-family dwelling is permitted use in this zone with consent from the board. We're asking the board relief for 240 square feet over the permitted 2,500 square feet and 1,248 square feet under the permitted 15,000 square foot lot area. As this house is existing, our total gross floor area is 2,740 and our lot area is 13,752. And we feel this is a modest request. We've provided for 6 off-street parking spaces, 2 in the garage, 4 in the driveway, and we'll agree that the garage can never be converted into living space as well. Mr. Suri purchased this house in 1986 with the intent to use it as a rental property. Across the street, we have multifamily cluster dwelling complex, and surrounding adjacent property is zoned business, PB. There's an office building there. So we don't feel that the house remaining as a residence, two-family residence, is a very aggressive request. The residence will consist of 3 bedrooms, 2 baths on the upper level, 2 bedrooms, 1 full bath on the lower level. And as part of our application and as part of a conversation I had with Mr. Barton in the Environmental Protection Division, we understand that the application will need Suffolk County Health Department approval for the septic system. In summary, we feel that the request for the change will not cause any adverse impact on the community nor the environment. It is in some way self-created, mainly due to the existing size of the home and the lot area, and in no way will this request, if granted, create any undesirable change in the neighborhood.
Okay. All right. So you know, first of all, there's no action because we need the health department approval.
That's correct, yeah.
Okay, and then we secret, and then if the PAR comes out, and we'll give it to you, if you feel you want to reopen it, I'll give you that opportunity.
That
All
would
right?
be fine.
In the meantime, I'm going to adjourn it,
Mm-hmm.
okay? All right, but let me see if there's anyone here that wants to speak on this.
Sure.
Okay? Okay. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
Giselle, moving the second. All in favor?
Aye.
Aye. Motion carried. Okay,
Thank you very much.
thank you. Next case is case 16459, John and Barbara O'Mara, 201 Camden Avenue, St. James, location southeast side of Camden Avenue, south of Woodlawn Avenue, St. James, property zone R21. Request variance to increase the maximum height of accessory structure from 15 feet to 20 existing, increase the maximum floor area of accessory structure from 750 square feet to 1,581 square feet existing.
Good evening, Madam Chairman, members of the board. My name is Vincent Tremarco. I represent the applicant. Mr. Gleason submitted the affidavits of posting and mailing to Kelly Brown. At the outset, I'd like to thank you for granting us a rehearing with respect to this matter, and hopefully we can do it right this time and convince the board of our situation and what we stated the last time with proof this time. So the first thing I'd like to show you, and this is with respect to the height of the garage, and that's a letter from Robert Mavrakakis, a licensed surveyor, and basically he says that the date of the letter is May 9th, 2011. The total height of the garage at the above address, which is Mr. and Mrs. O'Mara's address, is 20 feet high. And this is taken from the lowest elevation around the perimeter of the garage to the top of the ridge, which is the point of the roof. So, you know what I'd like to do? I'm going to submit all my exhibits in one shot. They're marked, and then we can go through them.
Okay, perfect.
So,
Let me have them all and I'll do it. It's easier that way.
the first time we were here, it was thought that the garage was 22 feet high. It's not 22 feet high. It's 20 feet high, and that's been established by, as I said, Bob Mavrakakis, a licensed surveyor in the town of Smithtown and actually in the state of New York. The next thing that you have in your packet is a tax assessor's sheet, and it shows that the upstairs of the garage was used as an office as Mr. O'Mara used it since he's owned the house. Now, one of the things that we did in contemplation of what the board would want, and I think it was done the last time too, we abandoned the cesspool. There's no cesspool there anymore. There's no plumbing in the garage, so that and there's no heat in the garage. There is a staircase going up, and that brings me to the next point where you see a dormer. Basically, that dormer was built by Mr. O'Mara on an existing garage of 20 feet high, which was constructed probably in the 1910s, 1908 or thereabouts. The garage was constructed in a fashion that I'm going to have John Gleason testify to. The type of construction was construction that was used many, many, many years ago. It was called, as Mr. Gleason indicates to me, balloon framing. They don't allow balloon framing anymore because it has no fire stops. So at this point, I'm going to ask John Gleason to come up and testify under oath what he believes the existence of that garage to be and whether anybody added a second floor to that garage. And it's very important because obviously this board the last time thought we did that and we didn't do that. And of course, if we did, then we would have been suffering from our own illegal use. So John, would you come up now, and I'm sure the chairwoman is going to swear you in. And
Okay. May I have your name, please?
John Gleason,
And your address, John?
336 6th Avenue, St. James, New York.
Okay. Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
Yes, I do.
Thank you.
I'm here to basically reinstate the facts that I was at the last hearing, that the majority of this garage, except for what the dormer was built back in the mid-'80s by Mr. John O'Mara, but the guts, the main portion of the garage is built with basically true dimension lumber, actual 2x4s, actual 2x6s, and this was done on an inspection with you know, field holes and access points into the structure. That kind of dimensional lumber is really indicative of you know, lumber that was used prior to at least 1960 into that period before sawn lumber was used. An actual 2x4 right now is 3.5 inches by 1.5 inches, whereas this lumber was actually 2 inches by 4 inches. And but that was the case on the majority of this garage, except for, again, where the dormer was built. As you can see in the photographs and some of the diagrams, that was basically with newer lumber back in the mid-'80s, and that's what I wanted to clarify as far as inspections that I had performed at the garage. I believe I stated that at a previous hearing too. Thank you.
Okay. Thank you.
thank you. The next piece of evidence that you have in your packet, it's denoted as C, Exhibit C, are two pictures, and they're on one sheet. And the top picture is a case that this board handled. It was, the property is owned by Governale. It's on the same street as Mr. and Mrs. O'Mara's property. It's at 165 Cambon Avenue, St. James, New York. And that particular property, there is a garage which this board granted, and I got to put my glasses on. It granted a height variance from 15 to 21 feet for a new detached 750 square foot garage. So the board down the street from Mr. O'Mara in 1999 granted a 20-foot high new garage to be built. The garage is less than a quarter of a mile from the O'Mara residence. Looking at the bottom picture, that's case number 12937, and it was done by Mr. Maloney. It was a garage that was built on 12 Astor Avenue in St. James, basically around the block, and it was granted to increase the square footage from 750 to 1,634 square feet, including a roof dormer. Interestingly enough, that's what we have here, and you can see it in that picture. The height was 21 feet, and the board granted it. The board gave approval for the additional floor area, obviously, and this particular garage also had a full-size staircase to the second floor. Now, I know the board gets suspicious when they see a full-size staircase, but many people don't like to use a pull-down staircase or a scuttle hole and walk up a rickety type stair hole or rickety ladder. And that's the reason why you see staircases in these garages. It's easy to carry stuff up and down. In this particular case, as we indicated, the garage, when it was used for an office, did have plumbing and apparently had heat. We've ripped all of that out, and we've taken the cesspool out. So with respect to the character of the area, there are two other units which this board granted. So we're not without precedent. And, you know, this is our fault. It's not your fault. We should have brought these up the last time. In any event, going to Exhibit D, which is the fourth page in your book, in your packet, is the picture that we produced for the last hearing. And all we're doing with submitting that picture is to show you the relative height of the garage vis-a-vis looking at it from Cambon on Avenue. I know there was some miscommunication, but nobody ever said that this was a picture that was done in 1908 or 1910. It certainly does indicate that in 1970, this garage existed the way it did, with the exception of the dormer, which Mr. O'Mara built so that he could put the staircase in, and, you know, when you go up the stairs, you wouldn't bang your head. The rest of that dormer contained the bathroom, which is now ripped out and not part of the structure. And that's why that picture is put in today. We didn't intend it to be a 1908 picture, and it certainly wasn't. The last thing that we did in our exhibits is to give you a copy of the history letter. Now, that history letter goes into a couple of things, and I think that's where the mistake really started out. You'll see that the history letter states that there was a CO for a two-story frame dwelling, 24 by 32, and a barn, 988 square feet. Because they were built prior. Now, the barn that we're talking about in this particular case is a different structure. That's a structure that's in the back of the property, which is part of the subdivision map application, which we have agreed to throw down. So that's going to be demolished. And that's what that's talking about. And if you go down further and you look at what was CO'd, it had to do with the house, the one-family dwelling, and a swimming pool. What the history letter states is, in H, submitted survey reflects second-story addition to the detached garage with balcony. There's no record of a permit. There is no permit for the structure itself because that was built prior to zoning. We do indicate and certainly admit that we did build the dormer. We did put in that staircase, and we did put a deck on it, which we've indicated in the plans that we're going to remove the deck And where that sliding glass door is, which shown on the plan, we'll either put in a window or we'll board it up or close it up. It really has no consequence. So that's where we think all this confusion came about, because there was never a second-story addition to that detached garage. There was no record of a permit for the initial structure because it was built many years prior to the zoning. The next person that I want to call is John O'Mara, and I want to have him sworn in, and he'll have to swear under oath whether he built the second story on that garage or when he bought it, it existed. And obviously, if he won't do that, then we have a problem with the case. So I'd like to call John.
Good evening, John O'Mara, 201 Cambon Avenue, St. James.
Okay. Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I do. I just wanted to state that when I did buy the house in 1984, that structure existed. And the ridge was never raised. The only work that I did on that garage was the dormer so I could access the stairs, and we put the deck on the back and sliding glass doors. I also have one of the neighbors here that lived in that house, that lived on that street prior to me buying it. And if need be, he could come up also and reiterate what I said.
All right. Just let me, before you sit down, let me just make sure I understand. You're going to be removing the deck,
Correct.
removing the sliding glass door and replacing it with windows,
Correct.
or boarding it up?
Correct.
Okay, I just want to make sure of that. Okay, thank you.
I'd like to.
Just a minute, I'm running this show, not you.
Yeah. Get it.
I'm going to take a minute and just go through the last findings, because I think those findings, again, not the board's fault, but were based upon a premise that was inaccurate. Inaccurate mostly because it was our fault that we didn't present the last time what we should have presented. But, you know, the history letter as interpreted by this board was that the 988 square foot barn on the site was built on the site prior to town building permits and so forth. Well, it wasn't a 988 square foot. It was the larger two-story original garage or structure that was there. The 988 square foot barn was the piece, the structure in the back, which, as I said, we are removing pursuant to the subdivision application. As I said, we're going to remove the deck, and we're going to close off the window, the sliding glass door, or put in a window. The fact that you go on to say that the fact that these additions were constructed in violation of the zoning ordinance. What was constructed in violation of the building code, which was Mr. O'Mara not getting a permit, was the dormer, and I guess obviously the bathroom that he took out, and the cesspool and so forth. But it had nothing to do with the 988, because that was the barn. That's why we ended up with all of this confusion. You indicated the last time, and I hope we've covered that there isn't an undesirable change in the character of the area, because this board granted 2 variances which are equal to or greater than what we're requesting tonight. So it's not going to affect the neighborhood in any way. We don't require a floor area ratio, and you granted us a bunch of variances the last time, which we appreciate, but we didn't ask for, nor do we require, an FAR variance. And my point is, there was indicated in the decision, it was kind of a crowding on the lot and so forth. But that's almost 3/4 of an acre. We don't require an FAR, so assuming that we would have started out anew, there wouldn't be an issue about an FAR, and permits would have been granted. We don't see this as aesthetic degradation. It's not any denser. Density goes by what your FAR rules are, and your FAR rules are complied with. So, you know, there wouldn't be any 50% denser than normal. You know, I guess you could look down the block and see that. Was there an alternate method? Well, I guess he didn't have to build the dormer, and he didn't have to put a bathroom in. The only thing we're asking you to do is allow us to keep the dormer, and you know that the bathroom is removed, the heat is removed, the cesspool is removed. So, yeah, there could be an alternate method, but he did it already, and we're asking the board, based upon the evidence that we produced and based upon its own 2 decisions, that this really isn't out of character of the area. Bob Mavrikakis did the survey of the height, and it turns out not to be 22 feet, but to be 20 feet. And if you do the substantiality test, it's the 15 feet to 20 feet, it's about a 15% increase. It's not the 47% that it was thought to be based upon the incorrect information that was either presented to you or you had before you. Was the difficulty self-created? Well, to the extent that we built the dormer and we built the stairway, et cetera, yes, it was. It certainly is a situation now where it's just a garage with storage upstairs. There was a case cited, Diane Polis, case number 15941. Well, we've cited the 2 cases that you have before you, and I think that certainly establishes in St. James that you have granted this before. So we asked the board for its favorable consideration. O'Mara didn't extend the garage from a 1-story to 2. Mr. Gleason testified to that. He's a registered architect. He testified under oath. I'm sure that he wouldn't risk his license for John O'Mara, and John O'Mara testifies under oath, and that would be perjury if he said that he didn't build the 2nd story, and he did. So we asked the board again for its favorable consideration. It's really not as bad as was presented the first time, and again, we asked the board for its favorable consideration. If the board has any questions, I'd be happy to answer them, and I do think that there's a neighbor here that wants to say something. Thank you.
Okay. Okay. I'll let you come up. May I have?
Hi, my name is Joseph M. Clark. I live at 185 Cambon Avenue, St. James, and I've been there since 1970.
Okay, raise your right hand first.
Okay.
Do you swear to tell the whole truth and nothing but the truth?
Certainly do.
Okay, I guess Clark is C-L-A-R-K?
C-L-A-R-K with an E, with an E.
Oh, with an E.
Yeah.
Okay.
And I just want to testify to the fact that John O'Mara is a person, and I mean this sincerely, of integrity and honesty and righteousness, and in the improvements, landscaping and everything around his house. If anything, it has been a welcomed addition to Cambon Avenue. The garage, there was a farm there before that owned by a Mr. Landerer who had some acreage there, and he kept pigs and that type of thing. And the height of the garage was definitely not changed, because I noticed, I walked down the block, and it was not altered by Mr. O'Mara or by anyone. And that's about it. I think he's a good person.
Okay, thank you so much. Okay. Planning, is there anything? No comments. Gentlemen.
Just a question for you. You said that there's a 988 square foot barn somewhere else on the property. I don't see it on the survey. Do you know where it is on the survey?
You know why you don't, Mr. Tanzi? Because it's not. I can give you a copy of the proposed map, which includes the barn, which is going to be removed. That's not it, okay? There it is.
What's that?
Yeah, this is this.
It's right there, and it says to be removed.
Ooh. Can you see what it is?
So that barn currently exists?
Yes. But will be removed as part of the conditions of filing the map.
Okay, thanks.
This whole thing here?
Yeah.
Okay. You see it? Okay.
You do? Yeah, sure.
Mr. Gleason just indicated to me that there is presently a permit to demolish that barn that we just showed you, Mr. Tanzi.
Thank you.
Just taking notes. Okay. Any other questions? And gentlemen, any other thing? Anything else? Okay, thank you so much.
Thank you.
I'll entertain a motion to close the hearing.
So moved. Second.
It's readily moved and second. All in favor?
Aye.
Aye. Motion carried. That concludes our hearings for tonight. Thank you so much.